Do you know the difference between direct evidence and indirect circumstantial evidence? Direct evidence. Direct evidence can prove a fact all by itself. It's straightforward. It does not require any inference. For example, an eyewitness testifies to what they actually saw. That's direct evidence. What many attorneys do not realize is that indirect circumstantial evidence is just as strong as direct evidence under the law. And there is a reason for this. If we needed a videotaped confession to prove every fact that someone drove irresponsibly, or that someone discriminated, or that anything in fact happened, then proof would be virtually impossible. So the law gives equal weight to circumstantial evidence as the same as direct evidence. Indirect evidence or circumstantial evidence suggests a fact by implication or inference. It's like putting the pieces of a puzzle together to get the true picture of what truly happened in the case. On its own, a piece of circumstantial evidence might not prove much, but when combined with other pieces of evidence, it helps form a clear picture that points to a particular conclusion or truth. The jury decides. Many times, the defense will attempt to defeat the plaintiff's case by arguing that there is a lack of direct evidence supporting the plaintiff's case. But in the court of law, circumstantial evidence could be enough to establish a fact. This is why it is essential to consider both direct and indirect circumstantial evidence, and the jury gets to give each piece the weight they believe it deserves. Follow us for more legal tips.